Hey everybody, welcome back to our lecture series. For today's lecture, we are going to continue with our progress of the social evolution of the Republic during the 19th century. But before we begin on our new lecture topic, I would just like to do a customary recap and just touch bases on what we last discussed. So in our last lecture, we wrapped up our discussion on women's movements and women's rights, namely the founding of Vassar College and how, to us today, it would seem excessive and a bit forced, but it was really a very liberal and liberating exercise for young women, even with the amount of chaperoning to go and to go to school. We also looked at such larger-than-life figures such as Carrie Nation. Carrie Nation, of course, achieved great fame and was able to really utilize the press like no female reformer before really had. She made a great name for herself going out there and smashing bars. She, of course, was into a lot of what we would consider, right and appropriate movements or ideologies. But back then they were very radical. She, of course, was in the temperance movement. She was against the consumption, sale, or use in any way of alcoholic beverages. And we also looked at masculine Christianity and figures like Amos Alonzo Stagg, who, of course, was a great proponent of athletics and Christian fellowship and brotherhood. All right, and with that being said, I'd like to jump straight into our lecture for today. And for today's lecture, we are going to look at the civil rights cases of the 19th century. This will be a three-part review or discussion examination of key cases that sort of round out the last third or quarter of the 19th century. Now, half we have discussed in previous lectures, secession occurred almost as a knee-jerk reaction to the election of Abraham Lincoln back in 1860, and war quickly followed. Fort Sumter was attacked early in Lincoln's first term, triggering the opening of hostilities in the United States Civil War. Now, the war raged for 4 long years and largely ended with the surrender of the Army of Northern Virginia at Appomattox Courthouse on April 9th, 1865. Now, the Civil War not only led to lasting changes in the social relations of the Republic, but also to the governing body of the United States, including the legislature, ideas for executives and so forth, and also the judicial branch. Most importantly, the judicial branch. The most significant change to occur with the federal judiciary was the death of Chief Justice Roger Taney during the Civil War. Taney, of course, as we have noted in numerous lectures and discussions, he had been a Maryland slave owner. He rose to prominence as a loyal lieutenant to Andrew Jackson during the Great Bank War of the 1830s. And he was finally, after the death of Chief Justice John Marshall, he was selected by Andrew Jackson to serve as the Chief Justice of the United States Supreme Court. And during his tenure as Chief Justice of the Court, Taney provided one of the most infamous decisions or opinions in court history. He provided the majority opinion in the infamous Dred Scott case and gave such a broad ruling, such a broad opinion that he sort of fanned the flames of sectionalism and discord even more. Now, with Taney's death in 1864, October of 1864, Lincoln was now free. The path was open for Lincoln to go ahead and name his successor. Now, Lincoln, by this time, had already named 4 Republican justices who were very much anti-slavery and anti-secession since his term began. And Lincoln chose to nominate Salmon P. Chase as Taney's successor. Now, Chase was the polar opposite of Taney in almost every regard. He had been a prominent Ohio politician, serving as governor of Ohio in the late 1850s, from 1856 to 1860. He has served as a federal senator from Ohio on 2 occasions, and lastly, he has served as Secretary of the Treasury. He was in that position under Lincoln's administration from 1861 to 1864. And Tawney had largely made his national identity and made himself in the Republic in the 1840s, and he had done so by representing fugitive slaves, and he was widely known as the Attorney General of runaway Negroes. It was meant it was meant as a put down, but he took it in stride. Chase was a member of the Radical Republicans, and he was a noted supporter of Reconstruction plans. As such, Chase was a supporter of the 13th Amendment, which followed the Emancipation Proclamations. And as we noted a number of times earlier, the 13th Amendment abolished slavery in the Republic and was first ratified by the state of Louisiana, whose legislature at the time was under a Reconstruction government. Now, Lincoln, of course, was assassinated in April of 1865 by John Wilkes Booth. And Lincoln's assassination brought to the White House Andrew Johnson, who, while being anti-secession, was also an unrepentant bigot with no compassion. Andrew Johnson had no compassion whatsoever for the plight of African Americans. He did not care about what was happening to the freedmen or the freemen. Johnson was openly hostile to any sort of protection that Congress wanted to impose. He vetoed every piece of legislation that came across his desk pertaining to African Americans, and Congress, in an effort to cut off presidential opposition, drafted and passed the 14th Amendment. Now, the 14th Amendment granted citizenship to African Americans and really to everybody, every person born in the United States. Up until then, your citizenship was really based on what your state determined. Citizenship was granted by the states, and the federal government sort of followed the lead on that. With the 14th Amendment, the federal government then took the initiative in declaring who was a citizen and who was not a citizen. With this, Congress and really the states had reversed the claim of Chief Justice Tawney that African Americans could never be citizens or have rights that the white man was bound to respect. There are 3 other provisions in the 14th Amendment besides granting citizenship to those born in the United States, with the exception of Native Americans. And those provisions are central to the civil rights case and really civil liberties in the United States as we know them today. They were at the time directed at Confederate recalcitrants who were attempting to use violence and terror to offset congressional Reconstruction. And they declared that no state shall make or enforce any laws that abridge the privileges or immunities of citizens of the United States. States cannot deprive anyone of life, liberty, or property without due process of the law, nor deny to any person in its jurisdiction the equal protection of the law. And it's really those two, due process and equal protection, that that all the cases that we will look at really sort of hinge on. Now, in this lecture, we're going to look at Supreme Court cases that, through the course of the last quarter of the 19th century, interpreted and applied the provisions of the 14th Amendment. As I stated a brief while ago, the Equal Protection Clause and the Due Process Clause gave the court the ability to strike down state laws. The court's use of these provisions and the interests the courts chose to protect remains some of the most controversial issues of constitutional law and of the Supreme Court's history. The Supreme Court was tested early by 2 cases which really tested the scope of the 14th Amendment's protection of individual rights against the states. The Slaughterhouse Case of 1873, and the first and really the Slaughterhouse Case is still pretty much considered a landmark decision, and widely cited in constitutional textbooks even now, constitutional law textbooks. Now, the Slaughterhouse Case goes back to 1869 when the Louisiana State Legislature passed a law creating a monopoly in the city of New Orleans for livestock slaughtering. The monopoly was given to the Crescent City Livestock and Slaughtering Company. They had secured their charter through wholesale bribery, and they shut out their competition, all the other butchers in the city. Now, the butchers who have been excluded from their trade by the monopoly filed suit in federal court. Their suit was based on 3 clauses of the 14th Amendment. The butchers claimed that the Louisiana state legislature had abridged their privileges and immunities, that the due process clause had been violated as they were unable to exercise their property rights by engaging in their occupation due to state hindrance. And they also stated that the creation of a monopoly favoring some butchers over others violated the equal protection clause, the equal protection under the law clause of the 14th Amendment. Now, it should be noted that all European Americans brought this did this suit before the court. In an interesting irony, an amendment that was put in place to protect African Americans was actually in this instance, it was actually being used to protect the rights of European Americans. It was an interesting irony to note then, and it's interesting to note now. Now, it is also really interesting and really of note to know that the group was represented by Joseph Campbell. Joseph Campbell was a former Supreme Court justice who resigned from the court back in 1861 to join the Confederate States. Campbell's return to the court was ill-fated, as his arguments were dismissed by his former colleagues who supported the state charter monopoly in the Slaughterhouse Case of 1873. Samuel Miller wrote the majority opinion, which largely echoed former Justice Roger Taney's opinion in the Dred Scott case. Now, the 14th Amendment had been intended to provide for one universal type of citizenship for all Americans. Miller ignored this and drew a distinction between American citizenship and citizenship of the states. This meant that the states were not required to provide their citizens with the same privileges and protections and immunities as the United States. Miller did not elaborate on the privileges covered by federal law, but did assert that powers for local and domestic governments, including the rights of persons and of their property, remain within the limits of state regulation. This ruling supported the Louisiana State Legislature's power to create a slaughterhouse monopoly. Miller's opinion did not address or recognize the butcher's claim that the due process and equal protection clause had been violated. This opinion was not universal. The decision had been a 5-4-1. Joseph Bradley and Stephen Field, they both wrote strong dissent opinions. Field writing that a citizen of the United States is now only a citizen of the state he is residing in. A clear indication that the original intent of the amendment wasn't being followed, wasn't being seen through. Bradley wrote that the law deprived a large body of citizens of liberty and property without due process. No dissenting opinion was raised regarding the issue of individual protections by the justices. And Miller's majority opinion stated that if the states violated African American rights, then the court would have grounds to act. So again, they in one respect, the majority opinion openly or blindly sort of disregarded the citizenship aspect of it, and sort of created an avenue, a segue for the states to later go out and enact Jim Crow laws. But it also clearly stated that that the amendment was designed to protect African Americans. Now, this doctrine, known as states action or the states action doctrine, opened the door for violence and shielded the perpetrator from any action by federal law. And with that being said, we'll break here. And we'll come back with another lecture. We'll come back and we'll examine the other seminal case, the Crookshanks case, which involved one of the most despicable massacres in United States history. But we'll discuss that in part 2 of our discussion of civil rights cases. And as always, I'm Ted. Hit like, subscribe, and comment, and let me know what you thought about this lecture.